Hello and welcome to the Freight Flow Advisor Brief. The Supreme Court just voted 9-0 on the Montgomery versus Caribe Transport 2 case. It was unanimous, not even close. Here's what you need to know about the ruling. Freight brokers can be sued in state court for negligently selecting an unsafe carrier. The federal preemption shield they relied on since the 1990s, it's gone as of today. Let's dig into what happened. So here's the case in plain language, because you don't need a law degree to understand the consequences. In December of 2017, a tractor trailer operated by a company called Caribe Transport blows into Sean Montgomery's parked vehicle on the shoulder of a highway in Illinois. Montgomery loses part of his leg. Now, Caribe Transport, the motor carrier, had a conditional FMCSA safety rating at the time. They had documented deficiencies in driver qualification, hours of service compliance, maintenance, and federal records showed Caribe had been involved in at least 3 major crashes in the last 5 months before the accident. C.H. Robinson, the world's largest freight broker, had hired Caribe for this load. Montgomery sued everybody: the carrier, the driver, and the broker. Every federal court he walked into dismissed his claim against the broker. Why? Because of a federal law called the FAAAA, 4 A's, the Federal Aviation Administration Authorization Act of 1994. And this broadly preempts state laws related to broker services. Brokers have been using that law as a legal get-out-of-jail-free card in exactly these types of situations for decades. Today, the Supreme Court, including 9 justices, 0 dissents, said not anymore. Justice Amy Coney Barrett wrote the opinion. Her holding: a negligent selection claim against a broker concerns motor vehicles, most obviously the trucks that will move the goods. That's enough to fall under the FAAA's safety exception. Federal preemption doesn't apply. The broker can be sued. Simple, unanimous, historic. Now, I want to pivot to Justice Kavanaugh and Justice Alito. They both wrote something separately, and every broker in America is already citing their concurrence. They agreed with the result. Brokers can be sued. But Kavanaugh added, the ruling should not be read to mean that brokers will routinely be subject to state tort liability in the wake of truck accidents. What that means in practice is a broker who exercises reasonable care and documents their carrier selection decisions can defend themselves. You're not automatically liable just because a carrier you hired was in an accident. The key words there, and I'm going to repeat this because it's the most important word in the entire opinion: document it. You have to show your work. You have to prove what you knew, when you knew it, and that you acted reasonably given what was available to you. C.H. Robinson went from a CEO saying on their earnings call just a few weeks ago that they expected to win this case to issuing a statement saying they respect the ruling and pointing to Kavanaugh's language about brokers who act responsibly. The biggest brokerage in the world just got beat 9-0, and their best hope now is the concurrence. Let's look at how Wall Street reacted. By mid-afternoon, while the S&P was climbing, RXO dropped nearly 8.5%, C.H. Robinson fell about 1.7%, Landstar slid roughly 1.7%, and truckload carriers, they were up because asset-based carriers have always been the primary defendants in crash litigation. Today, brokers join them. Now, here's a contrarian take that's already showing up in analyst notes, and it's worth sitting with. The ruling may actually help the biggest brokers at the expense of the smallest. RXO said it in their statement, and I'll quote directly: "We believe this ruling will expedite industry consolidation, strengthening the long-term competitive edge of larger players like RXO." Deutsche Bank came out today estimating that 60% of the brokerages sector faces meaningful financial exposure, about 30% of the overall freight market. But they called the C.H. Robinson sell-off a knee-jerk reaction, noting Robinson carries higher than average insurance and solid margins in its brokerage division. Their conclusion: the Supreme Court decision could instill greater discipline within the industry. Brokers will likely become more meticulous in their hiring practices. That's the consolidation trade. If you're a large, well-resourced broker with documented vetting, deep insurance relationships, and compliance infrastructure, today may ultimately be a competitive tailwind for you. If you're a small broker running carrier selection through email and a spreadsheet, today is a 5-alarm wake-up call. There are 25,127 registered brokers on FMCSA's books right now. A lot of them are not going to survive insurance repricing that's coming. Before we talk through that, I want to talk about Freight FA and its AI engine, Freight GPT. They exist for exactly the moment the freight industry is in right now. Here's a reality. The Kavanaugh concurrence basically handed brokers their defense strategy in one sentence: act reasonably and document it. Freight GPT helps you with both. It gives you AI backed cost estimates for LTL, FTL, intermodal, and rail, so your pricing decisions are grounded in market data, not gut feel. It helps you build a documented decision trail around lane pricing and carrier market conditions. The kind of paper trail that matters when someone asks, why did you price the load this way? What did the market look like when you made the call? It's built specifically for freight, not a generic AI tool trying to guess its way through your business. The brokers who are going to defend themselves well in the post Montgomery world are the ones who can walk into a deposition and show a coherent, data backed record of how they made decisions. That's not just compliance, that's competitive advantage. So if you're running a brokerage or a 3PL and you want to understand how Freight GPT works, go to freightfa.com. That's freightfa.com. Okay, turning back to the ruling. Here's the thing that the Supreme Court didn't answer, and it's the thing that keeps transportation lawyers up at night. Justice Kavanaugh's concurrence specifically flagged it. Federal law requires motor carriers to carry insurance. It does not require freight brokers to meet any specific carrier vetting standard. There is no FMCSA rule that tells a broker exactly what they must check, how thoroughly, and what constitutes a passing grade. So today's ruling creates a duty without defining it. Brokers are now legally required to exercise ordinary care in carrier selection. But what is ordinary care? Nobody knows. Not exactly. That vacuum will now be filled by plaintiff attorneys in states' courts, by juries, by states' judges, and potentially 50 different standards in 50 different states. The Transportation Intermediaries Association issued a sharp statement today. Their analogy cuts requiring brokers to evaluate safety of a federally licensed carrier is akin to asking travel agents to evaluate the safety of the airline that has received government authorization to fly. Now, that's a fair point, and it's the foundation for what comes next: a push for FMCSA to create a federal broker safety vetting standard, a defined checklist that, if followed, gives brokers some type of rebuttal presumption of reasonable care. That lobbying fight starts today. Until it ends, the legal standard is whatever a jury says it is. So let's close this out with some action steps, because this industry doesn't get paid to sit still. If you're a broker, you should be getting legal counsel on the phone today, not next week. Pull your carrier vetting process apart. Write down every step. Document what data you review, who approves it, and what triggers the rejection. Call your insurance broker. Your coverage structure was built for the world that ended this morning. If you're a motor carrier, FMCSA Safer Profile is now a marketing document. Brokers facing liability exposure will route around carriers with elevated CSA scores, additional ratings, or recent enforcement actions. A clean safety record is now a legitimate competitive differentiator. Price contracts accordingly. If you're a shipper, your broker contracts need a post-Montgomery audit, indemnification language, insurance minimums, carrier selection requirements, and start asking your broker partners, walk me through your vetting process. The ones who can answer clearly in writing are the partners worth keeping. So in closing, 9-0 is a staggering blow. The Supreme Court didn't create a new duty today. The duty to exercise reasonable care in selecting a business partner has existed in common law for generations. What they did was strip away the procedural defense that let brokers avoid ever having to prove they met it. The standard was always there. Now you have to show your work. So that's it. Thanks for listening today. If you've enjoyed it, make sure you share with a colleague in the logistics, supply chain, or freight space. If you want a deeper dive, head over to substack.com and search the Freight FA Brief. And as always, you can listen to this podcast on Apple and Spotify. We have the links in the article. And last, you can watch this podcast on YouTube. Until next time, this has been your Freight Flow Advisor Brief.